Welcome to EUPrivacyForAll, Session 17 on GDPR, Right to Object, Article 19. Negotiations regarding the right to object and Article 19 brought really clearly an opposition between the conception of European Parliament and EU Council on the scope of the right to object. European Parliament was focusing on this right to be exercised regarding the legitimate interest legal ground, in which case the data subject would have at any time and without any further justification the right to object free of charge in general or for any particular purpose. This right was also to be explicitly offered to the data subject in an intelligible manner and form, using clear and plain language, in particular if addressed specifically to a child. EU Council was focusing on direct marketing purposes. The wording referred to such a purpose, in which case the data subject shall have the right to object at any time. An obligation on the information of the data subject was also enhanced. In case of historical, statistical, or scientific purposes, the Council recognized a right to object unless there would be a specific public interest. In the final draft adopted, Article 19 focused on the right to object on grounds relating to the particular situation of the data subject at any time, and the scope was the one of the directives, that is to say, when the legal ground is either public interest or the authority vested in the controller, or the legitimate interest pursued by the controller. It includes profiling. The controller shall no longer process the personal data unless it demonstrates compelling legitimate grounds, such as overriding the interests, rights and freedoms of the data subject, or processing data in the frame of establishment, exercise or defense of legal claims. Regarding direct marketing purposes, the right to object could be exercised at any time and include profiling. Where the data subject objects in the frame of a direct marketing purpose, the personal data shall no longer be processed. Once again, at the latest at the time of the first communication, this right shall be presented clearly and separately from any other information. The data subject may exercise his or her right to object by automated means using technical specifications. Finally, in the frame of scientific, historical research or statistical purposes, as proposed by EU Council, the data subject can exercise its right to object regarding the situation that is particular and absolutely linked to his own situation, unless there is a public interest. Other provisions in GDPR specify modalities according to which a data controller should facilitate the exercise of their rights for data subject. For instance, providing means for requests to be made electronically. Moreover, responding to the requests in a maximum deadline of 1 month. And, if rejecting the reasons why data should not be processed anymore, providing specific reasons. Regarding direct marketing, it shall be opposed to at any time and free of charge. This right shall also be explicitly brought to the attention of the data subject in a clear and separate way. Once again, Recital 59 and Recital 125 mentioned the fact that member states could adopt some restrictions, specifications, and derogations. Article 14 also enhances the fact that the controller shall ensure fair and transparent processing and mention clearly the existence of this right. Currently, the directive lays down in Article 14 that member states shall ground a right to object at any time on compelling legitimate grounds relating to the particular situation of a data subject, in two cases when the legal ground is either public interest or the authority vested in the controller, or the legitimate interest of the controller. In the end of Article 14, it is highly enhanced that, notably regarding direct marketing, the data subject shall be duly informed about his right. What should accountable data controllers and processors get prepared for? First, bear in mind that the right to object applies only on grounds relating to the particular situation of a data subject, and based on two legal grounds only, the one of public interest or official authority vested in the controller, or the one of legitimate purpose pursued by the controller. This right can be exercised at any time, free of charge, and specifically regarding processing aiming direct marketing purposes. This includes profiling. The controller shall no longer process the personal data unless it demonstrates compelling legitimate grounds. So, for instance, the defense of legal claim or scientific research of public interest. The controller shall also provide means for requests to be made electronically. Respond without undue delay at a maximum of 1 month, and give reasons where it does not intend to comply with the data subject's request. Finally, as for other rights, member states can provide restrictions, derogations, or specifications to this right. What will be interesting is knowing more about member state specificities and European Data Protection Board or court's guidance on how to demonstrate compelling legitimate grounds.